Releases in legal malpractice cases. Good afternoon. I'm Neil Burns. I'm an attorney in Boston, Massachusetts, and I'm going to talk a little today about releases and how we do releases in legal malpractice cases. Typically, lawyers have malpractice insurance, and if they do something wrong and there's a claim or a lawsuit filed against them, their malpractice insurance kicks in. The malpractice insurance company hires a law firm, and these are very specialized law firms, very specialized groups of attorneys. We're opposing them all the time. They're very professional, very competent. And in the event we settle a case against an insurance malpractice company, we have our client sign a release. They draft the release. The releases are pretty standard, but they're pretty complicated as well. And a couple of parts of the release I want to discuss here for purposes of this video. And that is, there's two things, essentially the confidentiality clause and the non-disparagement clause. Sometimes it's mutual, sometimes it's just one way. The bottom line is you can't publish the results. So if you sue John Jones and you settle a case for $500,000, you can't publish those results in any way. You can't publish those results. So that's a consequence of signing the confidentiality clause. There's also a non-disparagement clause which says you won't disparage the attorney. Post something on his or her website saying, John Jones is bad, John Jones lost a legal malpractice case, John Jones testified that he blew the statute of limitations in my case. You can't do that under these releases, and sometimes people do this before the releases get signed, and that's problematic, and sometimes they're asked to take these things down from social media, and we can get that done as well. Again, these releases are complicated, but they're not overly complicated, and we can certainly explain them to our clients, and they're pretty standard when they come from insurance defense folks. They're pretty professionally done, and they do business that way. There's another type of release when the attorney doesn't have insurance, and we have those cases occasionally as well. They're more complicated because an insurance company promising to pay money, they tend to pay. It's not usually a problem. I've been doing this about 38 years and haven't had that problem more than once or twice. But when an individual attorney agrees to pay, he or she may not. So we have to put in protections, sometimes a lien against a home, sometimes a payout over time, so that the client won't file anything against the attorney, but the attorney will pay over time to make things happen. And sometimes we put in those releases that the collection costs, if the attorney doesn't pay, that he or she will have to pay our client's collection costs, which is attorney's fees, interest, things like that, court time. And we've won in all these, and we've spent a lot of time collecting on some of these. It's always much better if your attorney has malpractice insurance, and it's certainly something you can look up when you hire an attorney. The Board of Bar Overseers has a website. You can look it up, whether they have insurance or not, whether they've been reprimanded or not. If you have a case against an attorney and you want it prosecuted, call Burns and Jan. We're very professional, very effective. We've worked on these cases for more than 35 years, and we will get the job done. And when it comes time to signing a release, we know how to do it because we've done it time and time again. Call Burns and Jan. Free initial consultation, 617-227-7423. Thank you.